right, we're back on the record and we're calling the next case People of the State of Michigan versus Caleb Stewart. It's two file numbers, 21-6067FH and 21-6085FH. Counsel, you want to state your appearance for the record?
Melissa Goodrich, prosecuting attorney.
Good morning, Your Honor. James Gilbert here on behalf of Caleb Stewart, the defendant.
Okay, we also have Agent Fagan from the Department of Corrections here in the courtroom, as well as the defendant. It's one of these now becoming more frequent, but I love them. Everybody's in person for a court hearing. We are providing enhanced public access online for the criminal docket. We're here today for sentencing. And so, Mr. Stewart, have you had a chance to review the report and recommendations?
Yes, Your Honor.
Okay. And Mr. Gilbert, do you have any additions or corrections to the factual information in that report?
I do not, Your Honor. Thank
Ms.
you.
Goodrich?
No, Your Honor.
The advisory guidelines in file 6067 are scored at 36 to 90 months. And in file 6085, they're scored at 0 to 25 months. Mr. Gilbert, do you have any scoring objections?
I do not.
Ms. Goodrich?
No, Your Honor.
And Mr. Gilbert, anything you'd like to say on behalf of your client?
Yes, Your Honor. As the court well knows, is well aware that Caleb's always been kind of a project of mine and trying to help him out. And sometimes we haven't been very successful. But today, I think he's taken a major step forward in getting into the recovery court program. I think the court did a fantastic job of telling him how important it is that he stay with that program, attend the program, and complete the program because of the amount of months that are hanging over his head. He's never had this type of incentive with the amount of prison time that he'd be looking at if he fails. So I'm happy that these are one of the sentencings that I really like. If Caleb can get his act together and get off drugs and become a productive member of society. Thank you.
Thank you, Mr. Gilbert. Mr. Stewart, it's not required that you would make a statement, but it is allowed. Is there anything you want to say?
I just appreciate you guys giving me another chance. I've hit my rock bottom, so I think it's a lot different now. Like, I can actually see myself doing good, and just like since I've been in the program, I've had my first tax-paying job. Like, I can already see things moving forward, and it feels good. I don't think I need drugs to be comfortable or happy anymore. No, I just really appreciate you guys giving me another chance.
Okay, thank you. Ms. Goodrich, any recommendations from the people?
I would agree with the recovery court recommendation.
All right, well, Mr. Stewart, you're 23 years old. These are not your first felony convictions. And you have, as I understand it, a pending case in Otsego County that'll have to be resolved. You have a prior drug treatment court that you absconded from and were violated from, and the team saw fit to let you back into the program. I think you are in a different place in terms of your readiness to work the program. We've already seen in some of the recovery court review sessions, we've seen some progress. There's a lot more progress to be made. We're not anywhere close to being out of the woods, Caleb. But, you know, I'm hopeful. So I'm required to make certain findings before placing you in a drug treatment court program by statute. And based on my review of the pre-sentence report and some preliminary screenings and assessments, I do find on the record that you are dependent on or abusing drugs or alcohol. You are an appropriate candidate for participation in a drug treatment court program. You understand the consequences of entering that program and agree to comply with all its requirements.
Yes, Your Honor.
I find that you are not an unwarranted or substantial risk to the safety of the public or any individual based on the information that I have, and that you're not a violent offender. So that you do meet the statutory qualifications for the program. So in file 6067, on the counts of conspiracy to deliver methamphetamine habitual third and delivery of methamphetamine habitual third, I'm going to place you on probation for a period of 30 months in the Sheboygan County Recovery Court Program, subject to the conditions on pages 2 and 3 of the pre-sentence investigation report. Want to highlight what some of those are. By law, your driver's license is suspended for a year, and you can apply to the Secretary of State for a restricted license after 60 days. There's a $136 crime or state cost and $130 crime victim assessment. There's a recovery court fee of $600. There are supervision fees of $30 a month to the Department of Corrections. Court costs in the amount of $350. And I'm going to order that you serve 204 days in jail with credit for 204 days previously served. This sentence is a downward departure from the advisory guidelines of 36 to 90 months. And I find that there's a reasonable basis to depart from those guidelines in that Mr. Stewart is a eligible candidate and a willing candidate to participate in a drug treatment court program. In file 6085, I'm going to place you on probation for 30 months. Subject to the terms and conditions listed in the pre-sentence report on pages 4 and 5. I want to highlight some of those. You have to comply with all the requirements of the Sheboygan County Recovery Court Program. Again, by law, your driver's license is suspended for a year. You can apply for restricted after 30 days. In this case, I know it was a little unclear. I do think on reviewing the pre-sentence investigation report that for this charge of possession of, there's 2 counts, possession of methamphetamine, habitual third, and possession of contraband in the jail, habitual third, that being committed in the jail is a mandatory consecutive sentence. So I'm going to impose 0 days jail on that file. And so I'm going to give you no credit on that file, but I'm going to impose no jail. That is not a downward departure because the guideline range does include 0 months to 25 months. There's $136 state cost and $130 crime victim assessment. I'm not going to assess any court costs or supervision fees or drug court fees because we already did that in other file. I'm required to state the goals of the rehabilitation or the rehabilitation goals of probation. They are to address the needs identified in the COMPASS assessment and to complete the recovery court program. And also, Agent Fagan, I'm going to place as part of the rehabilitation goals of probation to resolve all warrants. I mean, there's a misdemeanor shoplifting warrant in Macomb County. And before we graduate you, we're going to take care of those warrants and make sure that you address all those issues. All right, you have any questions about that sentence, Mr. Stewart?
Okay.
That'll be the sentence of the court. You have the ability, if you wish, to seek leave to appeal from the Michigan Court of Appeals to challenge your conviction or my sentences. If you wanted to do that, you'd have to file an application. If you can't afford an attorney, we'd appoint one for you at public expense, but you'd have to ask us within 42 days of today. So we're going to hand you some paperwork right now explaining those appeal rights. 1 copy of in each file is for you to initial so that we have a copy of it, but we know you have it. The other one is for you to keep and fill out if you wish to appeal. Okay, so we're going to give that to you. And I'm going to find that you're not eligible for early discharge of probation because we're in a problem-solving court program. So I'm told otherwise, the law doesn't make that clear. That's my understanding.
Thank you very much, Your Honor.
All right, and Mr. Stewart, for missing your court date last week as a sanction for the recovery court team, that you're gonna spend the rest of the day with us here in the jury box, observing court, and you and I will talk about what happened during the day.
Okay.
So you can go ahead and have a seat in the jury box.
Nicole wanted me to go see her after court. Should I do that?
Yeah, that's fine.
I can take
You wanna
both.
take them? Okay,
I'll
okay,
take
go,
your
go
vote.
with Agent Fagan, and then when Nicole's done with you, come back. All right, we have Mr. Key in the waiting room, so I can bring him in.
Mr. Key, that's fine.
Yes. Message to connect this audio. You have someone in the courtroom ready to go?
Yes, I have Mr. Buning.
Okay, well, what I'm gonna do is I sent Mr. Key a chat message about connecting the internet audio. Sometimes when we remove them, and they rejoin, they get those prompts all over again. So I'm gonna go ahead and remove him at this time and let him call back in. And we'll call People v. Is it Bunning? Bunning, People v. Bunning, file 21-6123FH. You've got Mr. Bunning present in the courtroom with his attorney, Mr. Varga, and the prosecutor, Ms. Goodrich. And we're here today for a docket call. Mr. Varga.
Yes, Your Honor, noted for the record, Brown Park, on behalf of Mr. Buning for purposes of docket call. But I advise the court this matter has been resolved through the plea bargaining process. And Mr. Buning is prepared to sign the plea bargain that was negotiated on his behalf. And we're prepared to proceed to a plea taking.
Okay. Yeah, Mr. Varga, we can have the bailiff deliver documents.
Thank you very much, Your Honor.
We also provided the court amended information.
And I would now proceed to that amended information, Your Honor.
And you
You have a
consent to its
copy?
filing?
I would.
You have it.
Yeah.
Is that the fingerprint order?
That's not your fault. Thank you. Do my pleasure.
Okay. Can I call it today? Thank you.
All right, Mr. Bunning, do you wish to enter a plea according to the terms of this agreement?
Yes, sir.
Could you stand and raise your right hand, sir? You solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
You can go ahead and be seated. Yeah, would you state your name for the record?
Dakota Bunning, sir.
You know, Mr. Bunning, a guilty plea hearing is an important event because it includes the waiver of important rights that you have. So listen carefully. At any time, if you need to talk to Mr. Vargas some more, you just say so. Okay?
Yes, sir.
Okay. Now, you're offering to plead guilty to an amended charge of attempted possession of oxycodone. That is a high court misdemeanor. It's punishable by up to 2 years in prison and/or a $1,000 fine. And unless you're sentenced to more than a year in prison, I'm required to impose sanctions on your Michigan driver's license. Do you understand the maximum penalty that you can face?
Yes, sir.
Are you on probation or parole with anyone?
No, sir.
Were you on bond for any other case at the time of this matter?
No, sir.
Do you understand if I accept your plea, you will not have a trial of any kind and you'll give up all the trial rights you would have?
Yes, sir.
I want to go over some of the more important of those rights with you. You'd have the right to be tried by a jury, to be presumed innocent until proven guilty, and the right to have the prosecutor have to prove your guilt beyond a reasonable doubt before you can be convicted. Do you understand those rights?
Yes, sir.
At the trial, you'd also have the right to have any witnesses against you appear at that trial. You'd have the right to question those witnesses. And you'd have the right to have me order any witness to appear that you wanted to give testimony in your own defense. Do you understand those rights?
Yes, sir.
And at that trial, you'd also have the right either to remain silent and not have the silence used against you at all, or you'd have the right to testify in your own defense. Do you understand those rights?
Yes, sir.
You understand by pleading guilty, you're giving up all those rights?
Yes, sir.
And is that what you wish to do today?
Yes, I do, sir.
If your plea is accepted, you're also giving up any claim that it was caused by any promises or threats that no one tells me about today. Do you understand that?
Yes, sir.
And you're giving up any claim that it was not your own free choice to enter the plea. Do you understand that?
Yes, sir.
There are also some limits on your appeal rights. First off, a guilty plea, you waive the right to appeal, and if you wanted to appeal, you'd have to get permission by filing an application for leave to appeal. Do you understand that?
Yes, sir.
Secondly, even if the appeals court takes your case, which they wouldn't have to, the types of issues you could raise are more limited. If you went to trial and were convicted, you could raise any issue you want, but a guilty plea waives some issues entirely. Do you understand that?
Yes, sir.
The plea agreement provides in exchange for your plea to attempted possession of oxycodone, the prosecutor will dismiss the drug double and the habitual offender second notice. Do you understand the terms of that plea agreement?
Yes, sir.
Mr. Vargas had a full, fair, and accurate statement of his terms.
It is, Your Honor.
Ms. Goodrich?
Yes, Your Honor.
Mr. Bunning, other than the terms of the plea agreement, has anybody promised you anything to get you to plead guilty?
No, sir.
Has anybody threatened you to get you to plead?
No, sir.
Is it your own free choice to plead guilty?
Yes, sir.
Knowing all this, how do you wish to plead the charge of attempted possession of oxycodone?
Guilty, sir.
So were you in Sheboygan County on March 18th of this year?
Yes, sir.
Did you have some contact with police on that date?
Yes. Yes, I did, sir.
At that time, were you in possession of oxycodone?
Yes, sir.
Did you have a prescription to possess that substance?
No, sir.
And you knew what it was?
Yes, sir.
Mr. Vargas had sufficient factual basis.
It is, Your Honor. Thank you.
Ms. Goodrich?
Yes, Your Honor.
Mr. Varga, are you aware of any other promises, threats, or inducements?
No, not at all.
Ms. Goodrich?
No, Your Honor.
And Mr. Varga, in your judgment, has the court fully complied with the court rule?
It is.
Ms. Goodrich?
Yes.
Mr. Bunning, we've given you a lot of information. It's possible that may have caused you to change your mind. That would be okay. So I just want to confirm with you what your choice is. How do you wish to plead the charge of attempted possession of oxycodone?
Guilty, Your Honor.
Well, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in both fact and law to believe you're guilty of that crime. So I hereby accept your plea. And you're guilty of that crime because you admitted a factual basis for the greater crime of completed possession. So we'll schedule sentencing in this matter for August 31st at 10 a.m. That'll be in person. I'm going to continue bond. And Mr. Bunning, I want you to stop by the probation department as you leave today and see if you can schedule an appointment, because you need to meet with the probation officer before the sentencing date so they can prepare a report for me that tells me all I know about you right now is that you possessed oxycodone on March 18th. I would guess you want me to know more about you before I decide your sentence.
Yes,
So
sir.
you'll give them all sorts of information about you, and they'll tell me what's going on with the case. So you're ordered to comply with the requirements of that interview process. You have any questions?
No, sir.
And I do want you've gotten instructions to follow through on the fingerprint order. You have to
Yes,
get fingerprinted from with the sheriff's department.
I apologize for that, too.
No problem, we'll just get it done. All right, anything further on that file, Mr. Carter?
No, Your Honor. Thank you very much.
Mr. Rich?
No, Your Honor. Thank you.
Have a good day, Mr. Dunn.
Your Honor, the court wants to call the matter of People versus Brady Freeman. That matter has been scheduled for sentencing today. But I've got a note, and I think the prosecutor can confirm from the probation department indicating they Mr. Freeman did not show up for his
Pre-sentence interview.
pre-sentence agreement. And then, so there's no pre-sentence report to be prepared. They could not get a hold pursuant to the information contained in the note, they could not get a hold of him to facilitate any type of contact. And I've attempted to contact him on several occasions and to no avail. I've also contacted, I thought he might be in Otsego County Jail because I know he had many matters down there, but he's not at that facility.
Okay. Hang on a second. What is your name on the iPhone?
Caitlin Aldridge.
Okay, let me rename that. All right, I'm gonna place you back in the waiting room momentarily.
Okay.
I just wanted to make sure that the unnamed iPhone wasn't Mr. Freeman. Okay. All right, so Ms. Goodrich, people's recommendation?
Your Honor, it does look like he's scheduled for 10:30, but I would ask for a bench warrant to be issued, and that would still give him 24 hours to turn himself in.
Okay, we'll, well, that's a real shame because he probably wasn't gonna get any, if any, more jail on the case.
I'm looking at a judgment of contempt that you issued back in,
Yeah, 35 days, credit for 35 days served. And when he entered the plea, we changed it to a PR bond. I think in contemplation that, based on the charge,
well, I advised the court that I've spoken to Mr. Freeman previously on several occasions, and Mr. Freeman could be characterized as what we used to refer to in my teaching days as a space cadet. Did not have a good grasp of responsibility.
All right, well, his decision not to communicate with either the court or his lawyer or the pre-sentence investigator, at least no other option. He's not here for sentencing. We're going to issue a bench warrant with no bond.
Thank you. I'll continue to try to look at it.
Okay. Let me bring in Mr. Key. Yes, it's audio connected. Good. All right, Mr. Key, can you hear us?
Oh, yeah.
All right, so next up is People versus Garrett Key, file 21-6120FH. We have Mr. Key with us by Zoom video. His attorney, Mr. Varga, and the prosecuting attorney, Ms. Goodrich, are present in the courtroom. And Mr. Key, we are providing public access online. Mr. Varga, today's the time and date for the docket call. Do you know how we're proceeding?
Yes, Your Honor, I do. Again, good morning for the record. Ronald Varga, Garrett Key. Your Honor, I spoke to Mr. Key yesterday at length regarding the plea offer tendered by the prosecuting attorney. At the end of that discussion, Mr. Key indicated to me a willingness to accept the plea bargain that was tendered to him by the prosecutor. I did not ask him to sign it because I thought he was going to appear in person today. But I would ask that Mr. Key give me permission to sign his name for the plea bargain. The plea bargain involves a plea to a charge of larceny of building and dismiss all other counts as well as all other habitual offense enhancements.
All right, Mr. Key, did you hear that Mr. Vargas indicating you've said you want to accept a plea to larceny in a building, count 2, and all else would be dismissed? Does he have your permission to sign your name to that agreement?
Your Honor, that's also on the
What-
Constitution, $100.
What is
Okay,
the,
and
I'm sorry.
there's a restitution amount of $100. So, Mr. Key, do you wish to accept that plea agreement?
Yeah.
And may Mr. Vargas sign your name to the agreement so we have a written copy of it?
Yes.
Thank you, Your Honor.
Okay, Mr. Key, would you please raise your right hand, sir? Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth? So help you God?
Yes.
Okay, put your hand down. Would you please state your name for the record?
Garrett Key.
All right, Mr. Key, a guilty plea hearing is important because you're waiving a lot of rights that you have, so listen carefully. If you need to talk to Mr. Vargas some more or have any questions, you just say so, all right?
Okay.
You're offering to plead guilty to count 2, which is a charge of larceny in a building. That's a felony crime, punishable by up to 4 years in prison and or a $5,000 fine. Do you understand the maximum penalty you could face for that crime?
Yes.
Are you on probation or parole anywhere?
Am I?
Yes.
No.
Were you on bond for any other case at the time of this matter?
No.
Do you understand if I accept your plea, you won't have a trial and you'll be giving up your trial rights?
Yes.
I want to remind you of some of the more important of those rights. You'd have the right to be tried by a jury, to be presumed innocent until proven guilty beyond a reasonable doubt. Do you understand those rights?
Yes.
You'd have the right to have any witnesses against you appear. You'd have the right to question them, and you'd have the right to have me order any witness to appear that you wanted to testify in your defense. Do you understand those rights?
Yes.
And you'd have the right either to remain silent and not have the silence used against you in any way, or you'd have the right to testify in your own defense. Do you understand those rights?
Yes.
You understand by pleading guilty, you're giving up all those rights?
Yes.
And is that what you choose to do today?
Yes. Yes.
If I accept your plea, you're giving up any claim that it was caused by promises or threats that no one tells me about today. Do you understand that?
Yes.
You're also giving up any claim that it was not your own free choice to enter the plea. Do you understand that?
Yes.
There are also some important limits on your appeal rights I want to make sure you understand. The first is that you lose the right to appeal, and if you wanted to appeal, you'd have to get permission by filing an application for leave to appeal. Do you understand that?
Yes.
And the second limit is that the types of issues you could raise are more limited. A guilty plea waives certain issues entirely that you could raise on appeal if you were convicted after a trial. Do you understand that?
Yes.
The plea agreement provides that in exchange for your plea to count 2 larceny in the building, count 1 and the habitual offender notice will be dismissed, and there's restitution agreed upon of $100. Do you understand the terms of that plea agreement?
Yes.
Mr. Vargas, is that a full, fair, and accurate statement of his terms?
It is, Your Honor.
Ms. Goodrich?
Yes, Your Honor.
Mr. Key, has anybody promised you anything other than the terms of the plea agreement to get you to plead guilty?
No.
Has anybody threatened you to get you to plead?
No.
Is it your own free choice to plead guilty?
Yes.
Knowing all this, how do you wish to plead to the charge of larceny in a building?
Guilty.
So on April 27th of 2019, were you in Sheboygan County?
Yes.
Were you in a dwelling house in Sheboygan County?
Yes.
While you were in that dwelling house, did you steal a purse, the contents of that purse, and a pillow from that dwelling house?
Can I talk to Mr. Varga?
Sure.
Sure, I can go down to my office. And I'll zoom in, they can put us in breakout room.
That's fine. Either that or we could clear the courtroom and let you speak in here.
Oh, that'd be fine too.
Okay.
Whatever's convenient for the court.
Okay. What we're going to do, Mr. Key, is because Mr. Vargas is here in the courtroom and you're on Zoom, I'm going to have to terminate the live stream and we'll start that back up when you're done talking to him. We're going to go off the record and we're going to have everybody leave the courtroom except Mr. Varga. So it's only going to be you and Mr. Varga talking so you can speak confidentially with him, okay?
Okay.
All right, so just sit tight while we do that.
Okay.